Some on the right and left have claimed that former President Trump could be disqualified from appearing on the 2024 presidential ballot. Several legal experts dismiss that theory as not just implausible but potentially dangerous. The legal theory goes that Trump could be blocked from the ballot point as Section 3 of the 14th Amendment to the U.S. Constitution, the disqualifications clause, bars individuals who have engaged in insurrection or rebellion against America, or aided those engaged in such, from holding office. The section also includes a provision allowing Congress to remove such disability via a vote of 2/3 in each chamber. However, the argument for the disqualifications clause does not hold water, according to multiple legal experts. They were all unsuccessful, von Spakovsky said. And every discussion that I've seen of this ignores the fact nobody ever mentions that they talk about Section 3 of the 14th Amendment as if it currently exists. Von Spakovsky noted the 2/3 vote provision allowing Congress to remove such a disability under the disqualifications clause and argued that the legislature already has removed the clause. In 1872, they passed the Amnesty Act, and it removed the Section 3 disqualification, with certain exceptions, including anybody who had served in two of the Congresses just before the Civil War, and members of the military, for example, who had been in the Union Army and had served the Confederacy, von Spakovsky said. In 1898, Congress passed a second Amnesty Act that completely got rid of all of those exceptions, he added. So the disqualification clause, it's gone. It's not valid anymore. Title 18, Section 2383 of the U.S. Code says that whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years, or both, and shall be incapable of holding any office under the United States. Several states are seeing calls to ban Trump from the ballot, but it is unlikely that the proposals will be taken up. Arizona Secretary of State Adrian Fontes said on a podcast this week that the state Supreme Court ruled there's no statutory process in federal law to enforce Section 3 of the 14th Amendment, and that, you can't enforce it. That's what the Arizona Supreme Court said. So that's the state of the law in Arizona. Now, do I agree with that? No, that's stupid, Fontes said, noting that he would follow the law in Arizona, even though he disagrees with it. Additionally, despite being a vocal GOP critic of former President Donald Trump, New Hampshire government, Chris Sununu, along with other state party officials, is staying away from a long-shot effort to keep Trump off the presidential ballot. Bryant Corky Messner, an attorney and prominent Republican who won the 2020 Republican Senate nomination, thanks in great part to Trump's support, is mulling a lawsuit if Trump later this year files to put his name on the New Hampshire primary ballot. Messner is very publicly questioning the former president's eligibility to run for the White House, and cites Section 3 of the 14th Amendment of the U.S. Constitution. That section disqualifies those who've taken an oath to support the Constitution from holding office again if they've engaged in insurrection or rebellion against the U.S. or given aid or comfort to the enemies thereof.